Madam, fresh matters.
Yes.
With your lordship, kindly, my lord, one matter for orders, my lord, the urgency, my lord, appellant has filed, the respondent herein, my lord, filed suit for injunction, declaration, and injunction was granted against the appellant herein, my lord. I have filed a writ appeal before the Court. The Court, after hearing, direct permitted me to take notice on the advocate appearing in the trial court. I have also served. And in the meanwhile, my lord, he is obstructing the appellant from putting up any construction, my lord. It is lying there in the for the last 2-3 months, my lord. We have made efforts, my lord. We have served the copy also, my lord. Because of that, my lord, the matter is urgent.
You are referring to a writ appeal.
I am the defendant number 10 in the trial court, my lord.
Oh,
Year MFA, my lord.
What is MFA?
Yes.
MFA is of which year?
MFA is of the year 2024, my lord, against the order passed on IA.
Have you complied with office objection?
Office objections complied, matter was listed before the Court. The Court, after hearing, directed me to move the, serve the copy on the advocate appearing in the trial court, since we have the urgency, my lord. Accordingly, I have served the copy.
We'll take it up on Friday.
Please, my lord.
Yes, Friday.
My lords,
1 minute will come. Yes. No, unless and until you comply with office objections, the matter will not be listed. If it is, give it to the court officer. If it is listed, it will come up on Friday. Friday, it will come. Yes. Yes. Yes.
It's not listed
Yes.
today.
This is with regard to a GNWC petition before the trial court. This honorable court, my lord, has already given directions to the trial court to wrap up the trial proceedings within an outer limit of 3 months. Despite the respondent has been taking continuous adjournment.
When was the order?
My lord, the order was
3 months time will complete when?
My lord, the order of this honorable court was in the month of April, and thereafter, my lord, there has been.
When was the order copy received? No, if it is 3 months, the court will ask for there will be a requisition from the court,
Certainly.
if at all it requires. For that, why are you moving?
Certainly, my lord, this is with regard to now what has happened is the trial court had closed the stage of cross-examination. I'm for the petitioner before the trial court, and in the trial court, since the respondent party had been taking continuous adjournments, the stage of cross-examination was closed, And now upon an application being.
That's what
made-
I'm saying. Now if it is 3 months, it's for the court to ask the time from this court when there is a direction.
Yes, sir.
Hmm.
Certainly.
We'll see that, we'll see that. Yes,
It may be taken up at the end of the list. Madam.
not possible. Yes.
Or with due respect, not to pressurize the court. So the matter which the writ proceeding arising out of an interim custody matter, my lord has third has applying the past an order, which was violated by the respondent, we brought it back, my lord recalls that. I was reserved for judgment, I know my lord is under tremendous pressure. 8 weeks have gone by. And the grandfather's birthday is on Saturday. We haven't had the visitation right as ordered by this court for 8 weeks. We've been paying the amount which my lord has directed us to pay diligently without default even today, even while the order is being made. I know, only a humble request, my lord, that the next Saturday is Ganesh Chaturthi. The children love the festival in our hearts. Grandfather's birthday is Saturday. Not pressurizing the court, I can only make a humble request.
Yes.
My lords, this is an RPFC 2018 matter. This honorable court has ordered for the retirement benefits of the respondent to, has to be issued to the petitioners. That was not, still it was not.
Please don't say that 2018, it has to be taken up right now. We'll see somewhere in the next 2 weeks.
No,
If the-
no, it is, there is an urgency because the retirement benefit is actually, it got.
When is
stuck.
the this order is passed, that impugned order is which year?
This is in the year 2021. 18 it is
Yes.
filed actually.
Yes,
Yes.
2020, 21, what is urgency in 2020?
No, urgency is because she is sick and she don't have any means of income to take care of herself and for her livelihood. And she's
That's
a
what-
elderly,
please understand.
she's a elderly.
Please understand what could, from 2021, 2024, nothing has happened. That need not happen tomorrow.
My lords-
Court will accommodate in the next 2 weeks.
My-
There are so many other matters for the court to look
My
into.
lords,
Please look.
it's a question of livelihood of the elderly lady.
What were you doing from 2021?
No, I have taken the NOC before some other.
Then no, the moment you have come on record, not that necessary that it will take it, pose this matter on September 10th. Yes.
Order has been passed. They own a sort of software tech firm. Interim order has been passed, restraining me from eliminating software.
Which year is MFA?
The NFA was now, I filed on August.
When was the interim order passed?
Order was passed on June 28th.
Take Saturday? Yes,
Is for eviction.
yes.
The fag end of this thing. At that time, notice the respondent filed an
No,
application.
no, first of all, what is that appeal you have filed? Which year is appeal?
But the, here is not that. 24 not fresh matter now.
Hmm.
But I am.
If you complied with office objections,
Complaint not.
it will come on Saturday, give the, yes.
My lord, the CH-21 matter with regard to the custody case, my lord, where your lordship has to furnish the video.
Yes.
At 21st, it was supposed to list it, but it was not listed.
21st is what?
Last Wednesday, my lord,
It was not listed. Post this matter on Saturday.
my lord, and then one more matter, my lord, this is also with regard to the custody.
Hmm.
Trial court has granted the father, my lord, visitation rights plus 50% of the vacations. My lord, this court has, because that time it was, child was 3 years. This court granted this stay with regard to 50% of the vacations. My lord, now.
When is the vacation now?
My lord, now Dasara vacations are coming up, my lord, this is the reason I'm moving.
October, September. There's still time for that. Post this matter on 4th of September. Yes.
My lord, I'm appearing, I am MFA matter 2023. I am appearing for appellant. This honorable court has granted maintained status quo order. In spite of granted maintained status quo, the respondents are putting up the construction. Hence, it is necessary. Kindly have it on tomorrow. my lord.
Respondent is served.
Sorry.
Respondent is served.
For respondent number 6 has been served. For others, we have notice has been issued, my lord.
Who is the one interfering?
Respondent number 6, my lord.
He is served.
Is on record.
Post on Tuesday. Yes.
This is a miscellaneous first appeal, my lords, challenging the order of the trial court which was passed on 6/8/2024, my lords, wherein I have been restrained from alienating.
Office objections are complied with.
My lords,
If at all they are complied with, it will come.
please,
Automatically, it will come up in the list for admission. So please ensure that
Please.
objections are complied with. Yes.
Please.
My lord, other day I moved the memo. Honorable court is given date today, but matter is.
For that office of 2024 one,
2021, my.
look at it. If the court, if it is so, what is the urgency?
My lord, execution proceedings is coming on 13, 30, 30, day after tomorrow.
Poses matter on Friday, yes.
Monday, but in the order sheet, it is mentioned as 10 a.m. to 4 p.m. It's not possible because my lord's when was dictating the orders in open court also, I am mentioning as 4 to 6. But it is wrongly printed in the order.
Well, let's just matter on Tuesday.
Page was adjournment, page 1, serial number 2, page 2, serial number 3 to 5, and the serial number 3, I'm appealing to the application.
The memo is filed, it's going to withdraw the writ petition. Memo is taken on record and the RP is dismissed as record.
Serial number 3, my lord, appear for the respondent.
Hmm?
Serial number 3.
Hmm.
Appear for the respondent. Senior counsel.
Have you informed the other side?
Serial number 3 only, I'm filing this memo for.
When she wants to withdraw a writ petition, what is your difficulty? Yes, let's,
Page number. Serial number 6 to 9. Page 4, 10 to 16. Page 5, 17 to 20. Page 6, 21 to 23. Page 7, 24.
yes.
For being spoken to, serial number 1, Nityananda, MK.
Here for the appellant. Appeal was dismissed on the ground of maintainability. But the office objection was raised that the commercial appeal is to be filed.
Oh, is this the one? Let us see, where is that order?
It's in 2C, my lords.
Page number,
See how?
order
Impugned
impugned.
order, my lords. Impugned order is at, my lords, is at page number.
In the
Page
in
number.
the Court of
15
Fifth Additional
of the-
District Judge and Commercial Court, Mangalore,
my lords.
National Highways Authority. I think the other day also we passed another order. This court on so and so, when is the date of order?
14/8, my lords.
On 14/8/2024, or 14/8/2024, I passed an order whereby the office objections are upheld with regard to the maintainability. Now, the matter is listed today under the caption for being spoken to. Then counsel appearing for the appellant submits that the said court, apart from the commercial matters, that is the court of the Fourth Additional District Judge and Commercial Court, DK Mangalore, apart from the commercial court, the court is taking up the other regular matters also. And in respect of the accusation, the National Highways Authority had filed several appeals before this court. And on those appeals were entertained, even and before the division bench, when such an order is passed, that the appeal is not maintainable, with later basing on a petition filed by the appellants, the same was, order was recalled and the matter was entertained. Considering the same, the order dated so and so is, is ordered and so is recalled. And the registry is directed to post this matter after office objections are cleared for admission. Yes,
Courted matter, serial number 2, Banu Prakash, petitioner. S. Raj Prabhu. I appear for the petition.
counsel for the petitioner is present, no representation for the respondent. Poses matter on Tuesday. Yes, next.
Serial number 3. Serial number 3 is 4.
Senior
Serial number
Not
4.
just referring to 3, not 6.
kindly matter next.
No representation for the appellant. At the request of counsel for the respondent, poses matter on 24th of September. Yes, next 4. This is 3. No, that was 6, no. No, it's 6, I think she mentioned. Come, No, why you want again adjournment in a withdrawal matter? I was thinking that you are mentioning some other matter. No, when they want to withdraw the petition, why do you want adjournment? And you, when I said, when I refuse your request, again, you're coming and mentioning, I thought this is the other number. Yes, 3,
Number-
dismissed, as withdrawn.
Onion KPS 4.
Respondent.
No representation for the appellant, poses matter for dismissal on 4th of September. Yes,
Number 5.
counsel, the respondent is present. Don't extend the interim order. Yes.
Cell number 5. Arvind Babu J.
Yes.
Veena PK.
Matter could be heard finally, both of us are ready. Readings, I think papers have already been filled up.
It can be, it can be. Yes,
If he is ready, it could be argued on merit.
yes.
Ready, Madam Sir,
Yes,
finally.
yes,
Appellant is the,
I am for the appellate.
appellant is a plaintiff.
I am for the appellate.
Appellant is a plaintiff
No.
or the defendant.
Defendant.
What is the suit for?
The suit is for the defamation. Defamation, declaration,
Declaration.
declaration.
Hmm.
There are two prayers. One was for the damages, other one is for the injunction.
Let's see the relief.
Yes,
Plaint. Where is the plaint?
plaint is there. Page number 36 on. In 1 minute. I'm just taking my glass. Prayers, page number 46.
46. Yes.
Wherefore, based on the above facts and circumstances, the plaintiff herein plays that this honorable court may be pleased to A1, for a judgment and degree of permanent prohibitory injunction restraining the defendants, its agents, representatives, attorneys, and all others acting for and on its behalf from further publishing, sending, writing, or speaking any derogatory, defamatory, untruthful, and obnoxious statements or any other communications in any other form whatsoever to any person, to any entities, legal or artificial, about the plaintiff, its directors, employees, affiliates, legal consultants, business associates, group entities, as the case may be. For a judgment and degree of mandatory injunction commending the defendants, its agents, representatives, attorneys, and all others acting for and on its behalf to immediately remove all the defamatory and scurrilous articles, voices, or writings posted on MyGate application, Telegram, and WhatsApp, or any other similar platforms or media about the plaintiff, its directors, employees, affiliates, legal consultants, business associates, group entities, or customers, as the case may be. 3, directing the defendants by way of mandatory injunction to provide an unconditional written apology to the plaintiff by circulating publishing in the media. 4, for a judgment and decree to recover a sum of rupees 7 crore on or such other amount as this honorable court may deem fit as an by way of compensation for the defamation and tarnishing of the image of the plaintiff.
Was it heard by the court or before?
No, my lord, this is the first time. No, earlier the matter came up, but they wanted to file their objections, and today is the first time I'm just started speaking.
No, because When I'm looking at the plaint, I think I have, but I've read the plaint earlier also, yes.
Milord, the first day I came for the argument on the admission, that day, it was directed to me to give the
No,
notice.
no,
to
it's
the
okay. No, no, looking at the plaint, I'm saying that I've seen it earlier.
And compensation for the defamation and tarnishing of the image of the plaintiff, its directors, its employees, their business associates, customers, and consultants with interest at 12% per annum from the date of filing the suit until the date of realization from the defendants and other assets for a judgment and degree for costs in the proceedings. Any other judgment or order that this honorable court may deem fit and proper in the facts and circumstances of the case may be passed.
You appear on behalf of the defendants. Have they filed any appeal before this court? Against,
Appeal in the sense-
in their suit,
Pending.
in the earlier suit.
No, no. There is other litigation under the writ side where they sought for a registration of.
So it's that in this para number 16, they refer to a suit. Para 16 of the paint, they refer to the suit. Whether that litigation has come up, I remember something passing some order in this, that's why I'm asking.
Milord, this is already disposed. There is no appeal filed.
Not writ.
No,
Against
I'm
this
talking about
original
paragraph 16
case.
OS number 1380. It is already disposed. There is,
When,
in September last year. 20
thereafter, no writ is filed by them.
Yes, there is no, to the best of my knowledge. To the best of my knowledge, there is no appeal filed.
Which writ petition is referring? That appeal is regular. There's one commercial proceedings in which the trial court rejected our plaint on the ground that we required to issue a notice under section 125 of Cooperative Societies Act. For want of notice, the plaint is rejected. Against with the RFA is filed, RFA is pending before this honorable court, where we have taken a contention that notice is required in certain circumstances where it confined to
Business
constitution, management and business. And other than the subject, it would not call for issuance of notice. Such a contention we have raised, it is pending before the division bench.
There is another writ
No,
petition also.
no, what is the IA that is sought?
Yeah, for injunction.
IA, injunction, the same relief.
Yes,
Restraining
same
them
release.
from publishing anything
same.
or, then please come to the order now.
Page number 21, Lord. Lord, my first
21.
21, Lord. 21 onwards.
Please read from
Para 8 onwards,
Yes.
reasons.
para 9.
There are 9. Lord, I just want to bring one small thing before I start this. There was a writ petition filed in 2022 by the respondent, 17662. While disposing that, this honorable court had passed an observation in the final order, saying that the builder would harass the apartment owners, even though they don't have any locus standi to file this writ. That is there. I will give a copy of that. That's a very important one. And they went for a writ appeal, and the writ appeal also was, the honorable single bench order was upheld. However, a liberty was granted to the respondent to approach the appropriate forum even if they have any other issues. That point is very important, Milord, because that's a point where I wanted to start with. Even this honorable court, while hearing the writ petition, had in their mind, it is an attempt of a harassment which is going to happen to the apartment owners.
Where is that order of the?
I'll just give that.
Where is the division bench's order? May I hand over this? This is filed along with the claim.
Para 7 is the 11th.
Lord, I just wanted to say this, in 17662, paragraph 5, it says in the middle, it is also made clear that the petitioner's challenge to the registration certificate in the writ petition to pressurize the members of the society to fulfill its ulterior motive, being a developer of the building in question, and therefore I do not find any acceptable ground to interfere with the submission made by the learned counsel appearing for the petitioner. This order was upheld in the writ appeal, my lord. Though there is a liberty granted to the respondent to approach the appropriate forum, still if they want. Then they have approached and there was a order passed. That order is under challenge, my lord, before this Honorable High Court by way of a writ petition.
Yes.
The challenge there is, my lord, the registration granted to the cooperative society was cancelled. You know, that was an honest order, so it has been challenged. That is pending before this. That's only for an information. Why I took this, this Honorable Court had felt at the time of hearing the writ petition, the motive is ulterior. So that's a point which I wanted to bring, because that is what is subsequently, which has reflected to this particular.
That's a simple writ petition where a party who is, or any of the observations that were made in the writ petition cannot be considered in a civil suit. Because what is it, according to the learned judge, the writ petition is not maintainable.
Yes.
And that impression of the learned judge or the observation is not based on any of the material. Now, how is it relevant in a civil suit?
Lord, I am not saying that this has a binding or any.
Then why are we reading?
No, I am reading because after this only all these harassments.
Let anything happen. No, the aspect is such a writ petition is not by maintainable by so and so. Your remedy is somewhere you go. That's a simple order of the learned judge. And now, please come to the order review.
Yes. Lord, the case of the plaintiff is that the plaintiff company has been primarily engaged in real estate projects and developed the properties into residential projects, condominiums, commercial projects, and business parks with over 20 years of experience. The plaintiff company has grown into one of the company's Karnataka's top construction companies, offering complete spectrum of design, build, residential and commercial construction services. The plaintiff further stated that as a result, the plaintiff's registered trademark Classic has become known as well as known mark in the real estate industry and has built a strong relationship with its customers over the years and achieved a high reputation and goodwill in the community. The company has received several awards, recognition, and achievements to this extent. The plaintiff stated that it developed the project under the trademark of Classic and Apartment Project Classic Landmark is proposed to be developed into 3 phases, with phase 1 consisting of 3 towers with 258 apartment units, phase 2 composed of 2 towers with 204 apartment units, and phase 3 consisting of 2 towers with 236 apartments. The plaintiff has received the occupancy certificate dated 24/11/2016, 2019, 20 for towers 1 to 5 from BBMP, and also received the commencement certificate dated 24/12/2020 for the towers 6 and 7 from the BBMP. It is further stated that the project has received vast recognition among home buyers and in the real estate market. Upon completion of the project, the plaintiff was preparing to transfer maintenance responsibilities of the apartment project to the Apartment Owners Association as per the agreed terms as well as the law prevailing in the country. Despite approaching the plaintiff to form an association under the provisions of the Karnataka Apartment Ownership Act 1972, the defendants and other collective members prepared a prepared to form a cooperative society with some hidden agenda of transferring the project land in their names. It is further stated that the defendants made scandalous and reckless allegations against the plaintiff in order to gain membership and also with ulterior motive to get the property conveyed in the proposed cooperative society name. The plaintiff strongly objected to the registration of the cooperative society. However, the defendants and the other members went ahead and registered the society. They started collecting money from other apartment owners without the plaintiff's approval. The plaintiff appealed to the jurisdictional deputy registrar of the Cooperative Society, Bengaluru, filing an appeal number DRB 3 Appeal 1 2223, sought to cancel the classic landmark owners cooperative society formed by the defendants and to prohibit the society from representing itself as the association of the classic landmark project. The district register of the cooperative society issued an interim order on 17/3/2023, staying the registration certificate and further proceedings, initiated and stayed order number so-and-so on dated so-and-so. The plaintiff further stated that in the social platform, My Gate for the classic landowners, the defendant number 1 makes derogatory remarks against the builder employees, relatives, and customers by calling them shoddy group, shameless followers, cheater, jokers, and goon. Further, the defendant number 1 also speaking false information among the apartment owners community, stating that the builders have been cheating home buyers in the name of UDS under KAOA 1972 Act and remortgaging land, which false, concocted and defamatory statement made against the plaintiff. The said statement made by defendant.
Yes, I've seen. Please make your submission.
Lord, my first point is, Lord, the dispute is between the builder and the home buyers. Very first thing is, it's not something different, it's a builder. Obviously, the home buyers will have certain grievances against any builder, and builder also would like to retain his piece of interest in every possible manner. The second thing, Lord, the suit is based, the whole plain suit is based on the forwarded messages. Nowhere the respondent is a party to any of this group. It's all based. If you look at the documents, you will see everything is a forwarded message. So
You accept it or you do not accept it?
no, I'm not accepting it because it is not relating to the builder at all. It is in a communication group where the owners, it's a restricted, limited group, where the owners of the complex discuss things, what is good and what is bad, what is happening to the litigations which are going, because so many litigations are going, so many disputes are pending. So to discuss this, there is a group. Now the question is, who created this group? If the order is looked at page number 22, it is said in between, the defendants have created a group on Telegram and WhatsApp. It's not that we have created this group. This group was in place much before the defendants bought their apartments.
No, if anybody has their grievance, there is a way to put forth it.
Yes, I'm not.
Everybody, either the builder or the inmate or the occupier of that owner, the owners or purchasers of that apartment, everybody, there is a manner in which you have to ventilate your grievance.
So it is.
Do it. If you have a problem, do it.
So
Not in the manner in which it is shown on the paper.
So, Lord, my submission is.
You can discuss your problems, sir, but you cannot make those kind of statements which will have an effect on the builder.
No, it is not. Nowhere it says it is on builder, my lord. That's what I'm saying. Even in the document produced as a support to the suit, Nowhere it says.
What is
illegal-
this to the Kabri law of KLM? What is KLM?
1 minute, my lord. Let me check
Page
that.
para number 14. Para number 14 of the order. Where are those WhatsApp messages? Please come to that.
Yes, I'll submit some document.
That is there. It is filed by whom?
You are the paper book.
You have
we
filed,
have.
right?
Can submit it.
Do you have this?
No, the document which I had was submitted just now, my lord. That's my copy. That's what I submitted.
Where are those conversations? Which page?
No, it's not in this.
346 onwards, your lordship.
Give him a copy. 346. Please look at those conversations. And from that, you tell the court how it is defamatory or how is it affecting your client. Take that. We'll have it on Saturday. This matter on Saturday,
Look, Saturday I'm not in town.
Friday, Monday, whenever you want.
Monday, my lord.
Monday, my lord.
Monday. By the time you please look at those messages,
Yes, certainly.
whatever that are filed before the court, according to you. I think it's for you to tell the court how it is going to affect you or how it is defamate. You tell the court. Basing on that, we'll pass order.
Monday, my lord.
Yes, Monday,
But can I have that bunch of document which is?
which you have passed on or she has passed? For that writ appeal order. Yes, next. File in the section, in the registry.
Yes.
Yes, next.
Serial number
Oh, no, that's mine.
6. Serial number 6. Telecast Reddy M for petitioner. Tanna Kumar.
Password, my lord.
Password not possible today.
Here is end up in portal.
Listen, today it's not possible because the court is not sitting in the afternoon.
Objections are not ready and serve it and.
If that objections,
Please,
pose this matter on Tuesday.
please,
Yes,
Number
Sir, on
7.
Saturday, my lord.
Saturday.
Saturday, please. I'll file it in the registry, madam. Sir, please. Sir.
Serial number 7. Ketan AC.
This case, he denies that she is the wife and he denies that she are the
Yes,
children. The lordship directed him to file the affidavit.
I have already filed it affidavit before.
Let's see. Where is the affidavit?
We have already filed it in office. But already filed, madam.
When did you file? What is the date of filing?
On 20th this month, madam. Just put up on record.
Doesn't appear to be. Look at it. Twenty-eight, 2024. But it's reflected in the cause list. Why not in the file?
Which was showing in the cause list also, madam. 7 point.
7.1. So if that is the case, let the court decide this aspect. It is arising out of what matrimonial proceedings?
The 125 proceeding. He did not, though registered post was served on his address, which he has shown in the petition.
No, it is a serious allegation. And when he is not, he is unconnected with the parties, he need not pay maintenance. That has to be gone into now.
Lord, he should have come after receiving, he received
So
that.
that's what, we'll impose some costs and we'll satisfy this order and remand it, because it's not fair on the part of the court
His
to
deposit-
pass orders on the ground.
He has deposited some arrears, my lord, 1,96,000.
But let it be, when he is saying that he is not the father, he is not the husband, that has to be inquired into.
I have produced 7 documents. He chose to stay
So
away.
all those documents is denying, let him come out, and there is a way to prove all that. And he is denying the paternity of the child.
Oh, I don't have money for my treatment and school.
To understand, those two issues are interlinked. Unless and until you are his wife and children or his children, he has an obligation to pay the maintenance. No, he is denying that itself. And that goes to the root of the matter, which has to be decided. We'll allow this application on costs. Allow in the sense that condonation and all he filed, that on some costs, which are payable to you. And let the trial court decide this aspect.
No, I'm not, I'm ready for the trial court, but he's making this type of serious allegation, baseless allegation, and he's escaping from the liability to pay maintenance.
Once, because, please understand, he has filed an affidavit before this court. Now, when he has first stated something before the court on affidavit, and if something the other way, the finding is the other way, then the court, I'll also record that if the stand taken by the husband is not true and correct, after an inquiry by the court, perjury the petition? When was your appearance before the court? When was the order passed?
Well, it's, the.
Order was passed on 24th March. When did you file your wakalat?
That's, I have no instructions with respect to that. No.
When
Sorry,
that's
ma-
your
sorry,
prime
that's,
ground
when-
that without an opportunity, then you have to tell the court.
I have filed the objections. Since the mediation, the settlement process was going on, I didn't file the assets and liability. The only request is let me file my assets and.
No, that's what, it will come with a cost. An order that is passed in March 2023 has to be set aside in 2024 in August. Who will answer to this delay? Who stopped you from filing your statement of assets and liabilities? Why should this exercise be done every time?
Please,
Again, from lower family court to high court to family court?
Well,
What is
it's,
this shuttle?
The only thing, only ground, not only ground, Malas, the instructions which I have is, since the.
Your instructions,
settlement
not
pro-
instructions. When you
Well,
are
that's,
appearing before the court, there should be on a question of fact and law. What is that fact and law?
Malas, the settlement proceedings, process was going on. So I was not able to file my assets,
How?
affidavit for assets and liabilities.
So you tell that, at least give the dates. When was the matter, when did you appear? When was the matter went for the mediation? When was this order passed? Why you are not able to do? Just like that, with a statement, nothing will do. You have to tell the court. Otherwise, we will not set aside this order.
I'll take instructions.
Yes, please take instructions.
Malas,
And
kindly-
please file the order sheet of the trial court so that the court will understand. That would self be sufficient. Yes, next.
Malas, kindly have it on next week.
The counsel for the petitioner shall file the statement of the order copy of the trial court.
Malas, we have filed the order copy of.
Not the order copy is, that is the docket orders everyday past order sheet for the trial court. Post this matter on 10th of September. Yes,
11th,
11th of September. Your matter is adjourned to, when is that matter adjourned?
Sorry, Madam. I'll find out, Madam. I'm sorry.
Yes,
I'll
next.
find out. I'll find out.
Yes, next.
There
Next
was
one.
disconnection. I'm sorry, Madam.
Yes, that's why
Sir,
it is adjourned.
petition
Yes,
file
12.
ಮಾಡಿ. Cell number 12. Revana Siddhappa.
Now it is rectified. Yes,
This
they are
case,
there. Yes,
Here for the respondent, I may be permitted to file my statement of objections.
yes. Have you given him a copy?
I'm serving it today. Because prior to this, I had not appeared.
Oh, this is the first time you are
First time.
coming. Yes, learn counsel for the petitioner responded is filed statement of objections. Learn counsel for the petition seeks time. Poses matter on 4th of September.
Great.
Yes,
Obliged.
13.
Cell number 13. Chandana Tariga.
Last occasion, my lords had directed me to file an affidavit explaining the deductions in my salary certificate. I need to bring it to the notice of this court that there is an update in his salary, that as of 31st of July, his salary is now increased to 2 lakh. And as such, that is his take-home salary is at 2 lakh. As per his entire salary certificate says 4 lakh 60.
That's what the court wants to know, how it is deducted.
Lux, that is the as per the latest salary certificate, it is at 4 lakh to 1 lakh 93, that is close to 2 lakh rupees, take home. And as such, the other deductions are there. And in terms of his deductions that was considered earlier, his income is now at 55 lakh per annum. As such, if your income is above 50 lakh, there is a surcharge of 15% that is deducted beyond the other 30% of flat rate, that 30.
That you can
tax-
tell before the
Well,
court.
that
You
is
can
there.
Raise the documents before the
Please, please.
court.
That is in respect. of-
Something you're telling which is very not so common, then that's for you to tell the court how it is.
Please.
That's why it is adjourned.
Manoj, that is in respect of the earlier salary, that was at about 1 lakh odd. Now his salary has been increased to 2 lakh.
We are talking about your earlier salary. We'll talk about this later.
Please.
The finding of the trial court is based on your earlier salary.
No, the same salary has been, his take home has been increased, that's all, Manoj.
Let's see, tell the court, like what is this, which half of the salary is deducted towards tax.
Manoj, that.
If you're getting 4 lakhs, if you're
Please.
taking what 1 lakh and odd,
Please.
so more than 50% salary is deducted towards tax. Under which provision? How is it happening? Let's just know.
Please,
You
please.
please tell the court. That's why it is adjourned. Why did you do that?
Manoj, I wanted to bring it to notice of this court that there is an update in his salary. His latest
That
salary.
is not necessary. First you have to
Direction
do-
is to file an.
First, you have to tell that, do the thing what the court asked you to do.
Please.
Then you can update the court on any other aspect.
Please. Manoj, we'll file an affidavit to that effect. My apologies.
You have done it.
Manoj,
This court on 13/8/2024 had already directed the petitioner. to find out the details with regard to the take-home salary and its deductions. The council seeks time. Pose this matter on 10th of September.
Till number 14.
Please, oblige,
Date of-
oblige.
Yes.
I appear for the petition. My lords,
Yes,
have served the respondent, but however, they are not present.
you have taken out notice.
I've taken out.
Where is that memo you have filed?
I have filed a memo also.
To
I've sent also to the respondent and also the advocate on record in the trial court.
the advocate representative of the trial court. Where is that? You have sent it by RPAD.
I have sent it by RPAD and I have
Where-
filed an acknowledgement before this honorable court.
Where is that?
Filed it.
Acknowledgement of serving the trial court advocate as per the, this is acknowledgement.
Yes, my lords.
No, we should know whether it is served. It is about you sending it. So we also know, we have to know whether it is served on him or not.
It's out.
Where is that?
I'll produce. another.
Please produce that. That is important. The petitioner shall serve the acknowledgement in respect of service of notice to the advocate for the respondent. Post this matter on when?
Immediate.
10th.
Till number 15. Ravi Shankar, CR.
1 minutes. Let's place 2 weeks. time. I
Question,
have to
Lordship.
File objection.
No, your lordship, because what had happened in this case, your lordship, we have filed before the Singapore court, there is an MC and also we have
1 week
filed
time.
the.
once. I'll file my return up.
Let it be 1 week. Let the proceedings not be, it can't go on.
Please, ma'am, it is my humble submission. ma'am. 1 week time. I will-
No, take 1 week time, but
Please.
proceedings shall not go on before the trial court.
It is my humble submission. 1 week time.
No, your humble submission is taken and court will adjourn the matter, but the proceedings cannot go on before the trial court. You can't simultaneously pursue two remedies.
Please.
It is submitted with the land council that already parties have obtained a
Lordship,
decree of divorce.
not decree had been filed before the Singapore
filed?
court. We wife is filed.
Now again, she filed another,
Another your husband filed before the MC court.
what has happened there?
That is, objection has been filed, he has
By
contempt.
the husband.
No, his
There.
husband only.
The wife had initiated the matrimonial proceedings in Singapore where the parties are residing. And in that, it is submitted
And
that
documents
the-
also produced, your lordship.
It is submitted that in that the husband has also filed his